Hello, everyone, and welcome back to one more session of Address Real-Time Dispute Avoidance Online Mechanism. Today, we have a very special guest with us, that is His Excellency and Ambassador. Let me bring in him. Our guest is Ambassador retired Menahem Kanafi. His Excellency is an advocate who has practiced in Israel and also in USA and has more than 24 years experience. So the topic His Excellency chose is dispute prevention. Am I correct, Your Excellency?
Yes, Dr. Reddy. First of all, thank you for having me here. It's always a pleasure. In a few minutes, I'll get back to my journey and my story, which is also um, quite involved with India, as you can see from my
Okay.
profile. But the thing that I want to talk about today is actually how do we you can't completely avoid conflict. Conflict are inevitable, but how do we avoid certainly getting into court, and how do we try to resolve them by ourselves? And that's what I'll be talking about. Yeah.
So in this regard, may I ask a question like some of the people nowadays use the term deal mediators, or in other words, where
Yeah.
the mediator is involved when the time of the contract itself, and they help negotiate or get the contract out open. In fact, I have seen Your Excellency's profile, and the term conscious contract was showing up there.
hmm
So, would your lordship like to maybe explain more?
Yeah, it is quite related to deal mediation, I would say. Let me just give a little bit of a framework and a little bit of a background to
Yeah.
maybe the best way to explain this is how I came to the field of conscious contracts, relational contracts. And so forth. So first of all, as you've mentioned, I was an ambassador. I was a foreign service officer for 25 years or more. So a lot of what I did was negotiation, of course. And in when you think about negotiations, you think about these kind of hardcore negotiations between the P5+1 and Iran, or perhaps negotiations between Russia and Ukraine, hopefully Israel, Palestine. You think of these real kind of zero sum negotiations. But as a diplomat, most of the negotiations that you're involved in are win-win. They're collaborative negotiations. So just for example, when I was serving as my country's consul general in Bangalore, we set up a fund together with the government of Karnataka to promote R&D projects, to promote startups and so forth. Uh, in those negotiations, we wanted it to happen. The government of Karnataka wanted it to happen. All of the innovation authorities on both, everybody wanted it to happen, and it was just a way of seeing about how that actually took place. And most diplomatic negotiations are like that. So they're truly collaborative negotiations. So after I retired, I came from that kind of mindset. And I went into when I went into private practice, and I saw how broken the legal system is. There's no need or telling you, as an expert in out of court resolution and so forth. Uh, it was I can't remember, one American, I think, Supreme Court justice once said that justice delayed is justice denied. You know,
Yes.
and that's certainly the case. The system is completely broken. I found myself learning mediation, qualifying as a mediator, and I joined a mediation firm in UK. And that was all well and good, and we did our cases here and there. And then all of a sudden, Brexit came around. And all of these contracts, commercial contracts, especially between British companies and, say, German companies or French companies, all of a sudden, where they were basically domestic contracts beforehand in terms of enforcement, all of a sudden became international contracts. The UK was kicked out of the Lucerne Treaty, which is a treaty in Europe for mutual enforcement of judicial decisions, and all of a sudden they found themselves basically with contracts which then had no choice of laws clauses, and they had no ADR clauses, and they had so my firm partners and I said, okay, now we're going to go in there and we're going to sell them on mediation. We're going to say, okay, you have these problems now, but you're going to mediate because litigation is really not an option anymore. Uh, at that point, we started thinking because you do that sort of thing, and we say, hey, well, why do we wait for these conflicts to happen? Why don't we go into uh, these firms and especially offer our services to law firms and to companies that's saying that we're going to rewrite your contracts for the new reality that exists between UK and European countries. Uh, and from there, I started delving into this kind of conflict prevention um, methodology. And in a very simple sense, you could see the kind of work I do as very, very complex ADR clauses. ADR clauses, which can be as long as the rest of the contract itself. Um, so that it's one way of looking at it. The other way of looking at it, which is how I look at it, is much more. It's a different approach. It's a different approach to conflict. It's a different approach, especially to contractual disputes. And that's how I got to this subject, was creating contracts which could deal with conflict basically before it arises.
Ambassador, may I ask your good self a question about something your Excellency has stated earlier, that is the relational contracts. Now, relational contracts are something different, in my opinion, compared to like a conscious contract or like a deal mediator. Maybe can your uh, Highness shed
Well,
some light on that?
I think when we're talking about these subjects, they're mostly, if you look at them, they're about mediation before mediation in a way, and
Yes.
that's kind of deal mediation. But in deal mediation, you don't. It's very present looking. You're looking at the way the deal is formed and what the details and what the details of the resolution will be. Whereas in relational contracts and conscious contracts as well, it's very much forward looking in the sense of what's going to happen if. Now, um, I have to take that a little bit back in the sense that um, traditional contracts, the contracts that we know, leases, sales contracts, distributor contracts, and so forth, they try to grant security by having a really long list of what ifs. If I'm 10 days late, then I pay this amount of liquidated damages plus this amount of interest. And if I'm a month late, then this side has the possibility of canceling the contract, et cetera, et cetera. So in 216, um, the Nobel Prize for Economics was won by a guy named Oliver Hart. He was at Cambridge, then he moved to Harvard. All these schools we only dream about. And his theory, which he did mathematically, but basically, when you boil it down into plain language, is if you try to foresee, let's say, 50 occurrences that might happen in your contract, it's number 51 that's going to happen, and that's what's going to get you. Some ship is going to run aground in the Suez Canal, and then all bets are off. That kind of thing. Um, so what the relational contract and what the conscious contract tries to do is, first of all, to establish what our guiding principles are. What is the principles of our relationship? And that's why it's a relation or a conscious contract, because we become aware of what is important to us. Why are we doing this? Why are we working together? And that's not a trivial question. That's not a trivial question at all. When you say, why is a landlord renting out their house, right? They might be doing it. We always say to make money, right? But when you go deeper into it, there's usually a reason why they want to make that money. Now, sometimes it's just greed, of course. But in a lot of cases, it's because they need that money for something else. They're renting their own house, or they're paying for their child's education abroad, or they're paying for medical treatments for their parents, God forbid, and so there's a reason. And if that reason is made obvious at the time of the formation of the contract, the whole approach to conflict resolution and dispute resolution is going to be entirely different. I like to use um, the example that, let's say I'm 2 weeks late in paying my rent, and my landlord comes and he says he's going to evict me and he owes me rent and he owes me all these things. And I say to him, the reason that I'm late with this rent is because I'm paying for a medical treatment, sending my mother abroad for medical treatment. Most likely the landlord will say, you know what? Take another week, you know? and just pay me when you can. So the relational contract gives a way to talk about these things. First of all, we set up our guiding principles. Why are we doing this? What are we trying to achieve with our contract? Why are we working with each other? And then the second part of the contract is then when something is coming up, when do we talk about it? And it's critical, a critical point. Again, as an ADR and a conflict resolution expert, you know the timing is always critical. That a conflict which you solve now is one thing, but if it goes on for 6 months, people have become entrenched, the values have gone up, and so forth. So the first question is when, um, and the second question is how do we talk about this? Because quite often, too often, when something I'm sitting in my business and something is going wrong, my supplier hasn't sent in the shipment of left-handed widgets or whatever it is. The first thing I do is I call my advocate, right? And I say, Joe hasn't sent me this thing. What are we going to do? And the advocate says, okay, we'll sue him and so forth. Does that really make sense? The first thing you should probably do is call Joe and say to him, "Why didn't you send this?" But that often doesn't happen, and we often run straight for our advocates. And we can write in the contract that I am obligated to speak with you, my partner, before I do anything else. And we also can talk about ways that I can speak with you. To speak for myself, I cannot stand getting bad news by text. I just cannot stand it. I don't mind if somebody calls me. I don't mind if somebody walks into my office. I don't even mind if they send me an email, but I don't want to see it on WhatsApp. Um, I see it on WhatsApp. Automatically, um, I go into some kind of defensive mode. So we can actually write that into the contract how we want our communications to take place, um, how we want to conduct the conversation. Now, maybe we know that, and you see this all the time, that things escalate when you try to negotiate by email. Um, there's
Yes.
no tone, something,
The tone and tenor are missing in writing.
exactly. It's all missing, and a phone call or a Zoom call can solve that. So we say we don't bring up substance in emails. We can bring up process. When do we want to meet? Where do we want to meet? But no substance. Only one line of substance, non-delivery of the left-handed widget. Uh, so we have our guiding principles. We have our dispute resolution system or governance system. Sometimes it's called in relational contracting. And only after we've negotiated those things out, then do we start talking about the actual deal points. What is it that I'm supposed to deliver? When am I supposed to deliver it? And that's of course in there. Um, but these kind of sets of crimes and punishments if you're too late or if you do this or if it doesn't meet the quality standards and so forth, all of that isn't in there because if those things happen, the answer is I pick up the phone and we begin to discuss. And then we make a structure for those discussions. And of course, if that doesn't work, then we cascade into mediation, we cascade into arbitration, we cascade into litigation. But we do before we go into a more formalized dispute resolution process.
Let me share a few examples, Ambassador. In fact, I had used a similar approach in my contracts, and people always used to criticize me, saying that my preambles are very long. They are 2 or 3 pages long because it is nothing but a reasoned contract rather than a reasoned judgment which occurs after the dispute. You are preparing a reasoned contract where you are writing why each party is entering into the contract. That's what I do. Many people criticize me saying I've been writing long preambles, but your highness has now stated the importance of that, so I have some tool to at
Yeah.
least support myself.
First of all, I'm not a highness, but that's for royalty. But I would say the answer is yes. And in fact, I have colleagues who've submitted these sort of contracts. And what is litigation about? They're very rarely questions of law, especially in commercial contracts. It's mostly questions of intent. It always goes to intent, right? If you write these preambles like you're talking, or what I call guiding principles, what you call through 2, 3 page, then the judge knows what the intent is. And
Yes.
I have colleagues in the United States that I've heard where judges have actually thanked them that all of this has been outlined at the beginning. of at the contract, because the judge says, well, now I don't really have any work to figure out your intent. I know what it is. I know what you meant, and then I know how to decide. Whereas, if it wasn't there, if it was opaque, just saying I'm delivering X, Y, and Z, then of course that's not there. So I've actually had judges thank some of my colleagues for writing those 2 pages. So I'd be willing to bet the people who are criticizing you are not from the judicial side. The judges like that. You're doing their work for them, and every judge likes you to do their work for them. That's very basic.
Well, Ambassador, in fact, I may share one more example of mine where, in fact, I had used the term conscious contract.
Hmm.
I did not know your profile at the time. I did not even find this term online, but I conjured up myself when I was writing a contract because there were one or two clauses my client was very skeptical about.
Hmm.
So I wrote that if those clauses have to be touched or reworked or rewritten somehow, it has to be through a conscious contract on a particular format and all those things. And only these specific people can sign on that. Anybody else signs that, that is not valid. Of course, a few of my
Hmm.
colleagues pointed out that you are now overwriting the Contract Act. But I said that's a decision which the parties are choosing, that nobody else are going to get this power. I'm not going to delegate anybody else this power. It's going to be with me, and I alone can rewrite that. So that was a conscious decision, of
Hmm.
course, of a particular aspect. And so I
Right.
use the term conscious contract in that.
So we're using that a little bit differently. Again, in a sense, the
Yes.
work you're doing is very similar there. Again, when you're talking about these preambles, but again, consciously to go into it, not just. But the point is first of all, in most contractual systems, certainly in the common law systems that you and I
Hmm.
are trained in, you can write whatever you want into a contract, if as long as it's not opposed to public policy, not illegal, not opposed to public policy, morality, etc. Right?
Yes.
Anything else you can write in there only in case if you have remained silent on something, then the act comes into play, or in the commercial code, for example, if you haven't written in where the goods are to be delivered,
Yes.
right? Um, and if so there it's the normal business, the place of business of the recipient or something like that. If you write into the contract, it's somewhere else. You can write whatever you want in. Again, not opposed to public policy. It can't be on the moon, etc. The point is to do things first of all mindfully and second of all intentionally, and that's what the consciousness is at the end of the day. It's knowing what am I doing. That's the mindfulness, is what am I doing and why am I doing it. And that also then helps. First of all, it prevents it prevents confusion in the future,
Yes.
uh, because you can always go back to the contract. And that's another thing that I always make sure to do, is to write contracts in plain language
Yes.
that my parties can understand. And I've gotten pushback on that as well, from people who saying, for good reasons and for bad reasons. Good reasons is, well, this has been tested in court and we know, and this is protecting our client, etc. And some of the bad reasons is as well, if anybody could write a contract in plain language, there wouldn't be work for lawyers anymore. So uh, doctors have their professional language and we have our professional language. That's something I reject. But the idea is to have a contract that the parties can open up in a time of conflict. They can open up, look at it, and say, this is what I meant, and this is why I did it. That's my mindfulness and my intentionality. And this is how I talk about this conflict with the other party. So those are definitely points that are all bound up as well with using plain language.
Actually, Ambassador, I thank you for a lot of information you shared because Ambassador has actually reinforced my way of working. I use plain language, I use conscious contact. Of course, not necessarily the same terminology, but that's what I
Sure.
do. And thank you. But we're also reaching the end of time, and of course, I'd like to listen to more. Maybe we can have a longer session in the future. But on
I'd
one
be happy
uh, lighter movement, may I say that the future contracts may even include delivery on moon. Now that the world,
to. Yes. We're getting closer to that. We are
yeah.
getting closer, especially with, I mean, so a private company has landed on the moon now, right? It wasn't so successful, not as successful as India, of course, but a private company has landed on the moon, and with time, that's going to open up a whole new field of law. And as you say, contracts on for performance on the moon, I can definitely see that in our lifetimes.
So with that, I thank your Highness, of course, or Ambassador, as your Highness suggested. So thank you once again for the time, and thank you.
And thank you for hosting me.